Mr. Mkwena. Good morning, everybody.
Good morning, Chair.
Are we ready?
We are ready, Chair.
Thank you.
Yes. Mr. Gonsalves, before we proceed further with your evidence, just to recap, could you please capture a brief synopsis of the testimony that you adduced before the Chair yesterday? Just capture the essence so that you can be able to follow from where we have left yesterday.
Certainly. Good morning, Chair.
Good morning.
So perhaps let me start off by saying that on the 9th of August 2012, the CNR consortium informed Transnet that they would tender for both the diesel and electric locomotives. On the 17th of March 2014, a locomotive supply agreement was signed for 232 diesel locomotives between the CNR consortium and Transnet TFR. Prior to us signing that locomotive supply agreement, Transnet had informed us that the assembling and manufacturing of the 232 diesel locomotives would take place in Bayhead, Durban, as opposed to Kuduspoort in Pretoria, and they requested that we provide them with an analysis of the cost impact of assembling and manufacturing in Bayhead as opposed to Kuduspoort. And even though the locomotive supply agreement had a definition of contractor facility saying either Bayhead or Kuduspoort, there was an amendment to that stating that it was going to be at Bayhead. The contractor facility was Bayhead. Then on the 11th of March 2014, after the request from Transnet to provide an impact analysis of moving from Kuduspoort to Bayhead, a letter was sent to CNR, to TFR, stating that the amount was 9.7 million rand. That was the impact of the additional costs associated with the move from Kuduspoort as opposed to Bayhead. Then on the 10th of April 2015, there was a board meeting, and at the board meeting the minority directors were presented with the contract for BEX, and they objected very strongly to this when they saw that the contract contained provisions of a fee that could have gone up to 370 million rand for BEX. They had no idea who BEX was. There were no tender procedures followed by CNR South Africa. Despite all of that, the company, CNR South Africa, signed an agreement on the 23rd of April 2015 with BEX, and they were able to do that because CNR had 4 directors on the board, and the minority directors only total 3. Then we subsequently received a document dated 21 April 2015, where CNR South Africa produced some calculations showing supporting an amount of 287 million rand as an indication claim. We felt that the document was very poorly drafted and quite amateurish. Then in July 2015, there was a variation order that had been put together by BEX, signed by Jeff Wang of CNR South Africa and Anoj Singh of Transnet for an amount of 647 million rand. The calculations show an amount of 719 million rand, less a 10% discount, amounting to 647 million rand. And then lastly, on the 16th of August 2016, the minority directors met with the executives of Transnet. That included the CEO, the CFO, the head of legal and compliance, where we expressed our concerns around the BEX contract. At that meeting, we provided them with documents showing that BEX was, and subsequently we emailed it to them and presented hard copies to them, showing them it was a sham company. The SABC documents showed that the director, there's one director only. It was an exempt micro enterprise with a turnover of less than 5 million rand. We showed them that there was a document claiming that the initial amount was 287 million rand. We showed them that the amount had increased to 647 million rand. The only document we were not able to show them that meeting, because we didn't have it in our possession at that stage, was a document that Mr. Garma had signed, the acceptance letter of the variation order, because we only received that subsequently from Hogan Lovells.
Yes. And yesterday, we parted ways at the point where now this matter was referred to KPMG, and you were now informing the chair about the two reportable irregularities. And you have also done that up until page 13, paragraph 46. You were just about to elaborate on the contents of that paragraph and to proceed with your evidence from that point. Could you please take us through those relevant facts?
Certainly. Chair, I think maybe even though we're going to start on paragraph 46, if I perhaps could go back to paragraph 42.
Yeah.
Because I think it's a natural flow of events. So on the 22nd of September 2015,
Yes.
Daisy Chang from CNR called me to say that KPMG was considering issuing a reportable irregularity. I called the audit partner from KPMG, and on that call he informed me that this was not the first reportable irregularity, an initial one, number one, which I refer to as the first RI. And the first RI was the Bex matter.
Yes.
I then sent an email to Mr. van Eckenstein, the KPMG audit partner, requesting that he send me all the information on the reportable irregularity. And that takes us to paragraph 46. And should I continue from there?
Yes, you may then continue from there.
Okay. Then subsequent, we informed the Indynamics board of this, and the Indynamics board...
I'm sorry. Is the conversation between you and this partner from KPMG, does this capture the gist of the conversation?
Subsequent to the call, I sent an email to all my fellow directors saying I've just had a call. I've literally taken this from my email.
So your call to him was more to find out more about the reportable irregularity that you were told he was considering making.
Quite correct, Chair. So I wanted to know what the second reportable irregularity was about.
Yeah.
I wanted to know what the first one was about as well, because we didn't even know there was a first one.
Okay, thank you.
If I understand your evidence is that despite being the minority shareholders, all this information pertaining to these irregularities or reportable irregularities were never conveyed to the minority shareholders up until the time when at least that information came your way. Am I correct?
Chair, that's quite correct. We only knew that there was a first reportable irregularity when the second reportable irregularity came to our notice.
Yes, and it was at that point then when it sought clarification. What does the first irregularity and the second one entail?
Quite correct, Chair.
Yes.
Prior to the telephone conversation that you had with the partner from KPMG, did you get to know?
So my conversation with KPMG was on the 22nd of September 2017, and the Hogan Lovells response to KPMG took place in terms of Annexure 20. I'll give you the precise date. It seemed that that was on the 5th of September 2017. So, and it seemed there's an annexure to it with the actual reportable irregularity to IRBA from KPMG, and that took place on the 12th of June 2017.
That is the first one.
That's correct, Chair.
Okay, thank you.
Do you have any idea as to why this crucial and vital information, which ordinarily a shareholder must actually be told about, why was it kept away from the minority shareholders?
Chair, we have no idea, and you'll see that we were very, very upset that there could be a reportable irregularity, and the board, the other directors in the board not being informed about it, and the other shareholders not being informed about it.
And this was kept away from you despite the full knowledge from the majority shareholders that you had serious concerns that you have raised about the tax issue, and have even elaborated as to why that money should not be paid to the consortium. Am I correct?
Chair, that's absolutely correct, and I think that's probably the reason why they kept it away from us, because they already knew that we had concerns, and what KPMG was just supporting the concerns that we had, just confirming what we had already believed.
Yes. You may then proceed with your testimony from paragraph 7.
So I was saying what happened is on the 27th of September, there was an Dynamics board meeting, and they expressed their concern in paragraph 46 and demanded that a meeting be set up immediately with between the company, management, KPMG, and the shareholders, and whatever legal advisors needed to be there.
Yes, proceed.
And then what happened next is on the very next day, I spoke with Charles Yu of Hogan Lovells because I knew that they were the legal advisors to Synopsis South Africa, and on that call for the first time that we realized that the first RI, reportable irregularity, dealt with the BEX matter. He also informed me on the call that Hogan Lovells no longer wished to act for the company on that reportable irregularity and to provide any advice to them. The reason for that is that they had heard that one of the BEX directors had a relationship with the Guptas. Those were his exact words. And you will remember that in Annexure 20, that's the response that Hogan Lovells gave to KPMG on behalf of the company to support why they believe that the BEX issue was not a reportable irregularity.
Yes. Now, just to seek clarity, here the reason is given that one of the BEX directors. I thought that yesterday you informed the chair that this BEX, which ultimately, was paid these huge sums of money, it only had one director. That's because it was dormant for some time, and at the time when it concluded the agreement, there was only one director.
Chair, that's quite correct. There's Mark Shaw, I believe his name is the only director on the date. Look, subsequently, whether new directors were appointed or whether he resigned as a director, I'm not sure of the history post that date. So there could have been new directors on the board that had a relationship with the Guptas, or he could have had a relationship with the Guptas.
Yes. Now, these issues, which were now known to the consortium's, minority directors, was Transnet aware of these reportable irregularities, and whether or not KPMG did in fact report the issue pertaining to BEX?
Chair, I wouldn't know whether Transnet was aware of it. Remember that we had met with him in 2016, and this is in 2017. Whether the company informed Transnet about it, or whether Hogan Lovells did, I'm not sure. Yes.
Can I take you back a little bit? You said that one of the directors or the director of BEX apparently had a relationship with the Guptas, according to what you were told. And was it one of the directors that had the director, the sole director of BEX that had an agreement with your consortium, or was it one of the directors of the other BEX with which your consortium did not conclude an agreement?
Chair, I believe it was the BEX entity, the 2009 entity that we had signed the legal agreement with, because I think that the initial BEX entity was never involved in it. It was just a facade, and they were just using the company's probably name and registration number, and then probably acquired a shelf company, and it seems that acquired a shelf company, appointed a director, and then signed this agreement with, let's call it this new BEX. So my understanding from what Charles Yu from Hogan Lovells was saying was that the relationship was between the new BEX, one of the new BEX directors, or the director, and the Guptas.
So what I'm trying to establish is whether it was, as you understood, it was a reference to the sole director of the 2009 registered BEX, or the one that was
take it that at some point the minority shareholders did have a meeting with KPMG in order to discuss the first reportable irregularity. Am I correct?
Chair, that's quite correct. On the 10th of October, we met with KPMG and we discussed both the reportable irregularities. We made it very clear to them that the first reportable irregularity was a concern of ours as well, and that's the reason why we've never approved signing the financial statements of the company from 2015 onwards, but that we disagreed with them on the second reportable irregularity, and we'd be giving them evidence to support that.
Yes. And then what happened subsequent to that?
Then on the 20th of October 2017, we sent a letter to, which is Annexure 22 to KPMG, dealing with the second reportable irregularity.
Yes. May I refer you to folder 22, RG 22 Chair, is to be found on page 294, and request you, Mr. Gonsalves, simply to identify that document for us and simply take us through the highlight of that document.
Sure, Chair. This is a letter from CNR South Africa to KPMG on dealing with the second reportable irregularity. It's a document that goes, it's probably a 26-page letter that had probably a few hundred pages of annexures as well.
Yes.
What it was purporting to do is give KPMG confidence that this wasn't a reportable irregularity. The concern that KPMG had, I think they were in the media, there's a lot of, in the spotlight in the media. There was concern, I think, with any companies that had anything to do with rail. And you'll see subsequently that KPMG did resign as auditors. There were payments, project management fees that was paid from the company, CNR South Africa, to Endynamics. They were concerned that maybe there was no commercial substance behind these. And what this document purported to do was demonstrate that there was more than adequate commercial support and economic support for the project management fees, and that they were bona fide. I know I'm jumping ahead, but subsequently the new auditors that replaced KPMG withdrew the second reportable irregularity as an issue, but not the first one, the BEXT one.
Yes, that's fine. May I refer you back to a statement? And please go to page 14 and deal with the events from the 1st of November as per paragraph 51 onwards.
So on the 1st of November 2017, we had another meeting with Worksmans. Remember that they had been engaged by Transnet to look into the BEX matter, and we basically shared all the information that we had on the BEX matter with them. At that stage, we still didn't have the Hogan Lovells annexures. We just had their letter. We got that, I think, the next day from Hogan Lovells. And so we met with Harold Jacobs and his team.
Yes. And when you met with the Worksmans, were they aware that, KPMG has actually reported these two irregularities?
I can't recall whether they were aware of that or not, Chair, to be honest with you. I'm not sure whether we mentioned that in the meeting to them or not.
Now, you have highlighted the seriousness of these issues pertaining to the BEX, payment and how it was engaged and how the amounts escalated. Was the law, any law enforcement agencies engaged in order to deal with this matter?
So, Chair, subsequent to the meeting with Worksmans, it was apparent that this thing was just dragging on and is still dragging on. And we were concerned that quite a lot of time had elapsed before we were first expressed our concerns to the board and then to Transnet. And now Worksmans had been engaged, but we didn't see significant progress. So we took it upon ourselves as the minority directors to report this to the Hawks. And what happened was Lulumili Kate, as a director, put together an affidavit, and both Roland von Gericke and myself signed supporting affidavits.
Can I refer you to RG 24? Chair, it's on page 323. And if you can please identify that document for us, and to the extent that it's necessary, you may simply highlight the important aspects arising from that document.
Sure. Chair, it's page 323. This is the affidavit from Lulu Milik Party, and he basically summarizes that he's a non-executive director of the board, and he's deposing this affidavit in that capacity. He notifies them that KPMG has raised this reportable irregularity around the fees received from Transnet and the payments made to BEX, and he basically also attaches all the Hogan Lovells documents, which was an extensive record of all the contracts signed between BEX, the variation orders, etc., and he signs that on the 29th of 11th, 2017.
Now, when the minority shareholders approached the Hawks, what was the reaction of the majority shareholders? Were they aware? They simply ignored what was happening?
We, Chair, we informed them that we had reported to the Hawks because we thought it was a proper thing to do. We had nothing to hide, and we knew that it was going to obviously affect the relationship with them, but we let them know. Obviously, they weren't pleased with that.
Yes. What happened after the matter being reported to the Hawks? Do you know if the Hawks did anything about the matter?
The only thing, other engagement of the Hawks was a few months later. There was a Captain Frank Rangwashi from the Commercial Crime Unit of the Serious Economic Offences, and he met with Roland von Gericke, and just to understand a bit more about the matter, but no real progress on it. And since then, there's been no progress, no other communication from the Hawks.
Were the minority shareholders, did they make any follow-ups with the Hawks or with the captain?
No, other than that, there were been one or two discussions between them and Roland von Gericke. I know someone from the SIUs also made contact with Roland von Gericke, but I believe from the Hawks there's been no other communication.
Yes. May I then refer you back to a statement, page 14, and summarize for us the contents of paragraph 54?
Sure.
Yes.
Chair, so this is a few months later, 10 months later. We've insisted on a board meeting to understand a few things. Firstly, what's happened with KPMG's replacement auditor. We need to understand what's the status of the financial statements because we hadn't approved them from 2015. We need to also understand how the reportable irregularities have been dealt with, etc. At that meeting, we were informed that there are new auditors, Jateron and Peterson, and they've in fact issued signed audited financial statements in respect of the 2017 year and prior years as well.
When these new auditors were appointed, I mean, were the minority shareholders engaged in any manner?
Absolutely not, Chair, and there's enough evidence on record where we demanded that we have the right to at least interview who the new auditors were and also to inform the new auditors of the reportable irregularities. We thought it was improper to appoint someone and not let them know of the history and the background on the reportable irregularities.
Okay. It appears that the minority shareholders played no role in this company.
Chair, we were absolutely excluded from many, many important decisions, and that's why there's been quite a lot of tension at these board meetings.
Was it as a result of the position that you took in relation to the BEX issue, or were there any other things that were happening within the company that could have strained this relationship?
So, Chair, the BEX issues obviously definitely caused a lot of tension. The other tension is around the corporate governance. We insisted on, we demanded from day one actually that they appoint a South African financial director, a chartered accountant. We thought that would be useful for the company, ensuring compliance with all our rules and regulations. You know, we demanded that we have proper agendas for board meetings, that we have regular board meetings, that all matters pertaining to board meetings are circulated before the board meeting, etc. the Chinese directors obviously didn't like that approach.
Yes. You can then pick up with your evidence from paragraph 55 on page 15.
So following the board meeting, Chair, on the 25th of September, the next day, I wrote to the audit partner, Nadia Peterson, and I informed her that we were very surprised that the audited financial statements for 2017 had been signed off, and given that we hadn't had a board meeting for such a long time, and I also told her that we needed to understand how they had dealt with the BEX matter, and also any other RIs.
Yes. And in paragraph 56, we deal with quite an important letter which was written by Mr. Stephen Ntite, and the contents of which are quite crucial and important and relevant to the terms of reference of this commission. Could you please, take us through that paragraph and please read in full the contents of that letter, please?
Sure. Chair, so Stephen Ntite, who's from Endynamics, representing Kopana Kamata, was at that board meeting on the 25th of September, and it was quite a hostile meeting because the issue of BEX came up once again. And on the 27th of September 2018, Stephen Ntite signed a letter on behalf of Endynamics to the CNR board, and in it he stated the following: we as Endynamics regard the payment of 67,181,494 Rand, including VAT.
Mr. Gonsalves, I've just received a note that a 10 minutes break is being requested, Chair. There is a serious technical break that needs to be dealt with. And on those bases, I'm not sure whether we were able to capture all the evidence or whether we have lost any, or whether it's only related to the kennel.
Let's see. It looks like so far we have been recording. Yes, okay.
Yes.
So that's fine. So we can take the 10 minutes break to enable the technicians to fix the problem. Okay, it's 10:30, so 22:11 we will resume. Thank you. If there is need for more time, I will be told. Okay, we adjourn.
of Corrupt Activities Act 12 of 2004, in parenthesis PCCA Act. Roman numeral 2, you report this matter to the SAPS, in parenthesis Hawks, as having been the subject of extortion by BEX. Roman numeral 3, you report the behavior of BEX in terms of the Financial Intelligence Center Act 38 of 2001, in parenthesis FICA. Roman numeral 4, any other measures necessary to recover the monies that you pay to BEX. The next paragraph says, our position as Endynamics is simply that unless CNR demonstrates a willingness to correct the BEX matter and all the other issues raised above by the Endynamics directors, we are not willing to sign and confirm any B credentials of the joint venture, as we will be complicit in the very things we are complaining about, and we will demand the resignation of the Endynamics board director who sits on your board, as that amounts to conflict of interest.
Yes. Now, did the board of CNR or directors deal with the issues which were referenced in this letter? Did they take any remedial action?
Chair, despite numerous requests, we've seen no reaction by the CNR board or CNR to this letter.
Yes. You can pick up then from paragraph 57 and deal with the events from the 3rd of October 2018.
Sure. So, Chair, on the 3rd of October 2018, Lulu Miliklati, myself, Jeff Wang, the CEO, and some other CNR South African representatives met with Nadia Peterson of J. Teron and Peterson, and it was very obvious from the discussions that we had with her that she was not fully informed about the nature of the BEX issue, and that management of CNR hadn't provided them with the full information. Over the next few days, we proceeded to do that.
Yes. But did you furnish them with the relevant information? Did you give them the documents that would sustain, whatever complaint that you have in relation to the BEX matter?
Quite correct, Chair. We then emailed them all the BEX-related documentation.
Do you know whether did they react to same? What did they do with that information?
Chair, I must give them credit. They reacted very quickly. On the 8th of October 2018, they informed us that they had retracted the 2015, 2016, and 2017 annual financial statements. And I'll quote, as a result of information that came to our attention after the finalization of the above-mentioned reports. And in addition, they said, in parentheses, direct quote, well, we will need to reopen the December 2015 audit.
So they too consider this matter to be very serious?
Absolutely, Chair, and the latest audit report, as I'll talk about a bit later, as an emphasis of matter in relation to BEX.
Yes, and then on the 15th October thereabout, you wrote a letter to Mr. Peterson?
Yes, I wrote on the 15th of October 2018 to Ms. Peterson, and I made it very clear to her, and I'll quote, regarding BEX, we, in parentheses, the directors representing the minority directors, that is Lulamili Klate of Endynamics, Roland von Giericke from Global, and Robbie Gonsalves Cadies were dissenting directors when the board voted on the BEX contract. That is, we did not support the contract and do not support that the payment made to BEX was a bona fide payment for services rendered to CRRC SARS, which is CNR South Africa.
Yes.
For this reason, we wanted to know how this payment was going to be disclosed in the December 2015 annual financial statements. We have as yet not received a response from CRRC SARS on the 27th of September letter.
Did Mr. Peterson responded or reacted in any manner to this letter?
Yes, they no. Remember that Chair they withdrew the financial statements.
Yes.
For 2015, 16, and 2017. The next thing that we heard from them was on the 22 March 2019, so not very long ago, where I received a copy of the draft financial statements for 31 December 2018, and in that draft financial statements, the independent auditor's report included an emphasis of matter in respect of the BEX issue.
Yes, may I refer you to RG 29, Chair, that would be on page 340. If you may, please identify that document for us.
So, Chair, this is a draft independent auditor's report, and that would be from J. Theron and Peterson in respect of the 2018 financial statements, the year ended 31 December 2018.
Yes, and what are the issues which you wish to highlight to the Chair?
So, Chair, in the audit report, about in the middle, you'll see a paragraph with the heading Emphasis of Matter, and in it they state, we draw attention to the following circumstance. I won't read it out word for word, but in a nutshell, they say that there's a reportable irregularity, and there are 2 points here. One, they say, according to the information received, the proposal by CNR in respect of the relocation from Kuduspoort to Bayhead, this is direct words, significantly misrepresented the cost to Transnet. That was the issue. And
Effectively, it's the one you quoted in your statement on the last page.
Quite correct, Chair.
Yeah.
And then the second point that they raised is that CNR entered into an agreement with BEX on the 25th of April 2015, and that it appears that the payments made to BEX lack sound commercial substance and purpose.
Yes. Now, how was this matter ultimately resolved, if it was resolved? I mean, we know that the minority shareholders did interact with Transnet. They interacted with the Hawks. They interacted with the auditors. What happened ultimately with this matter? Do you know if the monies were paid back to Transnet, or whether are they being pursued? What is the status quo of all these issues?
So, Chair, to our knowledge from the company's perspective, absolutely nothing's happened. They've definitely not repaid Transnet the amount back, unless they've done that without informing us. And I understand that they're not pursuing BEX at all. Remember that we wrote to them demanding that they do that. We've subsequently written to them a few times and received no response from it. So I assume that they've done absolutely nothing about it. The only thing that we have managed to achieve is get the financial statements in respect of 2015, 16, and 17 retracted, and an emphasis of matter now included in the latest set of financial statements by the new auditors, stating that the BEX matter is a reportable irregularity and it hasn't been resolved.
Yes. And within the company itself, I take it that are you still the minority shareholder in the entity?
So we're still minority shareholders and we're still minority directors, other than Roland von Kierike, who's resigned since. I understand that we're going to have a board meeting next week. I assume that it's going to be quite a hostile one, but that's the plan.
Yes. Did the company, I mean, do you know if the majority shareholders have dealt with this matter or taken any further?
No, not at all, Chair, and I assume that if they had, they would have informed us. So my assumption is that they've done very little on it, if anything at all.
Have you or any of the minority shareholders interacted with the new board of Transnet? There was a new board that was appointed early last year for Transnet, and its chairperson, Mr. Popo Mlefe, gave evidence about 2 weeks ago here, and he gave evidence about how the new board is trying to recover monies that may have been paid to individuals or entities in a manner, in circumstances where they were not entitled to such payments. Do you know whether any of the minority shareholders have interacted with the board to say, are you aware of this? What is Transnet doing about it?
Chair, no, we haven't. Obviously, we reported this to the Hawks and we reported it to the old Transnet executives.
Yes.
So we haven't reported the new one, but I'm hoping that as a result of this testimony that I'm giving now,
Yes.
that Transnet now will engage with us.
Yes.
We're open, we'll share everything with them, we'll cooperate fully with them.
Yes.
We want this resolved, so I'd be very pleased if Transnet can engage with us and assist us
Yes.
with this matter.
Yeah, no, I would encourage you to take the first opportunity you get after you have finished here to communicate or make contact with maybe with the chairperson of the board of Transnet to bring to his personal attention that there is this matter, and you have given evidence about it. Probably, well, he was here yesterday morning. I think probably he may well be watching, but I believe that he would be interested to know about anybody that may have received payment from Transnet in circumstances that are suspect. So I would encourage that you do that.
Chair, we'll certainly take you up on that. I briefly met Mr. Molefe yesterday
Yes.
in the area outside.
Yes, yes. But to go back to this BEX issue, assuming that you were correct in estimating the costs at 9-something million rand, it means that since they were ultimately paid about 600 and something million, is that right?
647 million, Chair?
Yeah, 647 million. It means that if your estimation of the cost was correct, it means that there is a chance that more than 600 million might not have been justified that was paid by Transnet. Is my rough calculation correct in terms of what may have been unjustified to be paid?
So Chair, we believe that the full 647 million rand is unjustified.
Yes.
We were already paid 9.7 million rand. That
that was separate.
That was built into the price of a locomotive. So when we are putting the final price per locomotive,
Yes,
tender
yes.
document in,
Yes.
we included this 9.7 million rand and increased the price of the locomotives
Yes,
already.
I think you did say that.
So we've been paid, Chair, 9.7 million rand plus
Yes.
647 million rand. Even if the 9.7 million rand share was incorrect and it should have been 5 million, it should have been
Yes.
15 million, it should have been
Yes.
18 million. I think it's large, it's irrelevant.
Yes.
It was an agreed number. The
Yeah.
number was agreed with TFR.
Yes.
And it is built into the pricing of the final fixed price per locomotive.
Yeah.
So it's already been incorporated in the locomotive price.
So this whole 647 million rand that was paid on your evidence was really completely unnecessary, and there was really no cause for Transnet to pay that amount.
Chair, that's what we believe, and that's the reason
Yes.
why we approached Transnet. We thought perhaps there's
They
something
would
wrong
tell
with
you
our
something
thinking.
you didn't know,
Quite correct, Chair.
and nobody told you anything you didn't know up to now.
Chair, we're still waiting.
Yeah. Nor did your majority shareholders.
No, absolutely
You
not.
gave everyone an opportunity to explain to you what the justification was, both Transnet and the majority shareholders, and nobody told you what the justification was. Is that right?
Quite correct, Chair, and that's the reason why we felt obliged to report this to the Hawks.
Yes, yeah. But then the Hawks themselves don't seem to have acted as quickly as one would have thought they would.
That's quite correct, Chair.
Yes, yes, because you reported to the Hawks when?
That would have been towards the end of 2017.
Yeah, so there has been a whole year and a half at least.
Quite correct, Chair.
Yes. And have the Hawks been keeping you informed about their progress? Have they been in touch with you to make sure that you know that the delay is not because they are not doing anything, but they are working on the matter in any way?
Chair, there's just one meeting subsequent to that, subsequent to the affidavits being submitted, and that was with Roland von Gericke, but nothing came out of that meeting, and no new information. They already had all the information, so nothing. It was kind of just a brief update, but nothing came out of that.
So the meeting itself, you say there was really no value to the meeting as such?
No value whatsoever, Chair. I mean, I actually spoke to Mr. von Gericke, Roland von Gericke, this morning just to confirm that, and he confirmed it.
And the meeting had been asked for by them, by the Hawks, or you had asked for it, or your side had asked for it?
Chair, I don't know whether Mr. von Gericke had called them or they had called him for the meeting.
But a meeting had taken place, but there was nothing of any significance that came out of it.
Quite correct, Chair.
And the Hawks have never said to you, we need some more information, or your statements are not adequate, or your affidavits are not adequate, or there is something that your affidavits don't clarify, or they've never said anything like that to you?
No, Chair, absolutely not. I mean, we're willing and able to assist whenever. If anyone needs any information, we're willing and able to assist,
Yes.
whether it's Worksmans, whether it's Transnet, whether it's the Hawks.
Yes. Did you get to know who at the Hawks was assigned to deal with the matter?
So, yes, Chair. So the actual statement was signed in front of Lieutenant Colonel Percy Uckerman of the Germiston branch of the DPC.
I'm sorry, what's his name?
In paragraph 52
Yeah.
of my statement. You'll see in the last sentence, Chair,
Yes, yes.
it's Lieutenant Colonel Percy Uckerman of the Germiston branch. And then, Chair, in the next paragraph, you'll see Captain Frank Rangwashi
Yes.
came to visit Roland von Gericke.
Yes. Well, it may be that they have a lot of work, a lot on their hands, but one would have expected that at least they would keep you informed about what is happening. It's particularly important that they should keep, people who have submitted complaints to them informed, because there are all kinds of allegations against some of the law enforcement agencies that for some time they were not pursuing matters that they should be pursuing, and so on. So to deal with that, it's important that they should keep people who submit complaints to them informed, so that those people know that something is happening, because otherwise, if people think that they submit complaints to them for investigation and nothing happens, people lose confidence in them. So, okay, thank you.
Mr. Gonsalves, I just want to conclude your testimony by referring you to something that doesn't appear to be quite clear from your testimony. You referred to the two bags, you remember? I mean, you identified the one as the real bags that might be having capacity and necessary resources to can engage in the transaction of that magnitude. But you said that after you were finished with the relevant documents of these other bags, for want of a better word, I'll say that, the one with one director. Now, did you at any stage as the minority shareholders engage with this, the real bags, in order to find out as to what was happening? What was the distinction between these two entities, and why were you misled as you have testified to the chair?
So, Chair, you must realize that we only saw these agreements after they'd been signed.
Yes.
So, when BEX was first mentioned to us in that April 2015 board meeting, a document was put on the table that purported to show BEX's capabilities, and there were great color photographs of roads and bridges and trains, etc., showing the expertise of BEX. But subsequently, obviously, we know that they never signed with that BEX entity. And so it appears, I think Amabungani did an investigation, and it seems that there was a hijacking. In other words, they just used that company. Now, whether they did it to try and fool CNR South Africa, or whether they tried to fool us as the minority directors, I don't know what the intent was, but it is obvious that they'd hijacked this company, and that the intention was never to sign an agreement with the company, but rather to form a new company, have a very similar name. So there's confusion, and unless someone was astute and awake, they'd probably think that they were dealing with the same entity, BEX. But you'll see that the names are different, slightly different, but the registration number is very different. And the new BEX, the second BEX, is a company, a shelf company, just newly appointed a director, never traded, and that's the entity that they'd signed the contract with.
I mean, surely, flowing from that evidence, this could have not have been a sheer mistake. It appears that there was an effort to place what appeared to be the real BEX before the minority shareholders, while whoever that did that knew that this other BEX, the second BEX, was the one that they intended to conclude the agreement with.
So, Chair, from what we can see in the evidence in front of us, someone took the time and effort to try and create the impression that there was a contract that was being signed with the real BEX company. It seems to me it's definitely deliberate. It's not an error. If I was a director of CNR South Africa and I was signing a contract, an agreement with an entity, and I was going to be paying them initially a fee of 370 million rand, it went down to 67 million rand. And I must just add on the 67 million rand, it was 67 million rand plus VAT of 9.4 million rand. I doubt whether BEX ever paid the VAT across, so we're actually talking about 76 million rand. I would have made sure that just from a FICA purpose, that I was doing the correct work on it. And it would be very apparent that I was dealing with a shelf company, which would have concerned me. And they had the document in front of them. So they've actually shown us that they had the B certificate and they had the SIPC document. So they know that they signed an agreement with an entity that had just been newly formed and never traded before.
Yes. Now, what I want to understand also, which is not apparent from your statement, is we are dealing here with I'm now talking about your company. There must be obviously policies pertaining to procurement of goods and services. How was this BEX presented to the minority shareholders? What was the justification? How were they appointed in order to provide any service for that matter? I mean, you have told the chair clearly that within your entity itself there were resources that could have actually undertaken that task. But in this regard, here is BEX. Let's assume that you required those services. Ordinarily, how would that company be engaged?
So, Chair, that's absolutely correct. I mean, one of the reasons why we dissented as directors is we said that there were no tender procedures. Why did they not get quotes from other consultancies? So if they really needed someone and they thought that within their shareholder base they never had the expertise to formulate a claim, why did they not get quotes from other consultants? And the argument was that no other consultants would do this on a risk basis, and that BEX was doing it on a risk basis. They would only be paid a success fee, and everyone else would charge a fixed fee, and therefore they thought this was preferable. We obviously thought that this was laughable, given that BEX would possibly earn a fee of 370 million rand. We said that we thought that there were other entities far more competent than BEX that would have done the work for far less than 370 million rand.
Yes.
And if I may just add, I mean, there are other examples where, for example, we insisted as directors that the company implement a transfer pricing policy. And for that, they went out and got quotes from a few of the auditing firms. So for that, for that piece of work, they followed these procedures and got quotes. But for this massive amount paid to BEX, they didn't get quotes.
Now, lastly, I want to take you back to the meeting between the minority shareholders and Transnet officials. Firstly, the obvious question, was that meeting recorded? Is there a minute to that meeting? To the best of your recollection?
Chair, I think there would probably have been an email from us subsequent to that meeting to the other directors in Endynamics as a report back.
Yes. During that meeting, did this raise any eyebrows, or did any of the officials of Transnet appeared to be taking this matter very serious? Because these are serious issues that we've spoken about. You even take into the level of being a bribe that was not being entitled by any entity, and the amounts kept on escalating. Those are serious. One would have expected that there must have been serious steps, undertaken in that regard. What was your sense, of that meeting after you have concluded with the officials?
So, Chair, Mr. Gama, the CEO, did appear to be alarmed at it, and he even made a comment that if Transnet paid an amount to CNR South Africa, there was a possibility that Transnet could have paid other amounts to other OEMs. And so he's genuinely seemed concerned. I did yesterday give evidence that he had signed the acceptance of the variation order. That was a year earlier. It's a possibility that he had forgotten that he had signed it. It is a significant amount of 647 million rand, so it's a possibility that he did. The other executives didn't seem too perturbed about it. I would have expected a much bigger, stronger reaction from executives when approached by shareholders in one of the OEMs with so much evidence in front of them.
And most so take into account the money involved.
Absolutely, Chair. We're talking about a massive amount of 647 million rand, and I'm not sure whether the other OEMs are involved, but if they are, then maybe that double that amount, or triple, or even 4 times that amount. We could be talking about a significant amount.
Yes. Any other issue that you wish to highlight, having testified and furnished the chair with the facts as you did in a statement and also amplified it in your oral testimony? Is there any other thing that you might wish to highlight arising from this transaction and all the parties that were involved or engaged in it?
No, Chair, I think I've hopefully covered everything. We've taken a lot of time and effort to put this testimony together. It's over a long period and there's a lot of documents involved. And we hope that we've done it to the best of our ability. And I think it was Edmund Burke who said, all it takes in order for evil to triumph is for good men to do nothing. And we hope that we've done something that will try and address this, what appears to be very corrupt transaction.
Yes. Chair, that concludes our question for this witness.
Thank you. Now, in terms of the arrangement that BEX had made with your consortium in terms of the majority shareholders, they were to get about half or maybe a little more than half of what Transnet was going to pay. So do you know whether out of this 647 million rand, a certain portion came to the consortium in terms of that arrangement, or whether that all went to BEX?
No, Chair, of the 647 million rand, it all went to the consortium initially. But half of it was paid upfront, and the other half was paid in installments over a period, I think, of 2 years. It's the variation order, the details are in the file. I could probably find it, I think it's in Annexure 12 or 14. It's got the details on there. Perhaps we can turn to that.
What page is that again?
Chair will find it now. Yes, Chair, it's page 261.
Yes.
So, Chair, under point 2, the proposed payment terms,
Yes.
50% of it was payable
Within 14
days, and the other within 24 equal installments of 13.4 million. So, because this
Yeah.
was signed obviously in 2015, the full amount has already been received. Of
So-
them, sorry, Chair.
So the whole amount was to be paid to the consortium, and then in turn, the consortium would then pay BEX the agreed portion.
Correct, Chair, and then they received an invoice from BEX for 67 million rand plus VAT, and that is on, I'll try and find it now, Annexure 13.
Yes.
So you'll see, Chair, Annexure 13 is the BEX invoice for an amount of, so it actually says 647 million minus 580 million rand benchmark. So the fee 67 million rand plus VAT of 9.4. So 76.5 million was paid to BEX. And Chair, we did ask the question, it also seems odd why the agreement spoke about an amount of 100 million and there was an amount of 67 million. And what we were told was that the BEX fee was then also going to be paid 50% upfront and in installments, and they were going to get 100 million that way, and they rather said, can you pay us upfront and we'll reduce it to 67 million rand.
Okay, so ultimately, BEX got 67 million.
Plus VAT.
Plus VAT, yeah.
Plus VAT, Chair, yeah.
Yes. So, therefore, we are dealing with a situation, so the real entity from which Transnet should recover this 647 million, if indeed there was no lawful cause for it to be paid, is your consortium.
Chair, that's absolutely correct. So we,
Yes.
as minority shareholders,
Yes.
we've requested that the company repay the full 647 million rand back to Transnet
Yes.
and pursue BEX in respect of the 67 million rand plus VAT.
So it's a very strange situation. Transnet pays a lot of money to a company under circumstances which the minority shareholders of that company say, we are part of the company, we are minority shareholders, we know of no lawful cause why you should pay this amount. Please tell us why you should pay this amount to our company. They don't tell you. You ask the majority shareholders, you say, please tell us, we are part of the company. We don't know of any lawful cause why Transnet should pay our company this amount. Tell us why. They don't tell you. Transnet doesn't take any action to recover the money. They don't come back to you to say, no, actually, this is the reason. We don't know why the majority shareholders didn't tell you. There is a lawful cause. This is the cause. You go to the Hawks. You tell them exactly the same. You give them affidavits. You say, we're talking about money that has been paid to our company. We're saying there was no reason for it to be paid. It's taxpayers' money. Please take action. There must be prosecution. Investigate. They take the affidavits. There is one meeting. A year and a half later, you don't know what's happening. You have not been told of anything. There's been no arrest. You have not been told that, no, you are mistaken. We have actually interviewed the majority shareholders. They've told us the reason for the payment. There is a lawful cause. That hasn't happened. It's quite strange, isn't it?
Chair, I think you've summarized it very, very well.
How does it take a year and a half to conclude that kind of investigation? Somebody from within says there's no reason for this payment and says you can ask them. Majority shareholders, we have asked them, they haven't told us. We've gone to Transnet, we have asked them, they haven't told us what the reason is for them paying this amount. And a year and a half later, you sit there, you don't know what's happening about this issue. It's really a matter of great concern. I think, Mr. Mkwena, the legal team should take steps to be in touch with the head of the Hawks. I want to know what's happening about this and why should it take so long for the matter to be concluded. And I think the legal team can itself alert the chairman of Transnet of this evidence that we have had, and you will also take steps to bring this to his attention. It's all taxpayers' money. It's your money, it's my money, it's all our money. Transnet is a parastate, or is a state-owned entity. 647 million rand. That's close to R1 billion. You said you are done.
Chair, indeed, we are done. We will definitely pursue the issues that Chair have actually highlighted.
Yes.
And in due course, we'll be able to brief you with the outcome. We'll also make sure that we liaise with Mr. Gonsalves,
Yes.
so that he can also point us to the right directions of any other information or officials that he might have actually engaged with.
Yes.
With the Hawks, yes.
I've not been told what has happened with regard to the communication that I had said should be made to the Commissioner of Police with regard to the fact that Major General Boysen gave evidence that it seemed that not much was happening or had been happening with regard to any disciplinary action, or I don't know whether also end prosecution, but certainly disciplinary action with regard to Colonel Madu. I don't know whether communication has been sent to the Commissioner of Police and whether there is any response. Will the legal team look at that and update me?
Chair, we will consolidate all those issues and will ensure that we do brief you accordingly as to the status.
Yes, but the older ones mustn't wait for the new ones.
Definitely.
The older ones, I need to hear what the latest is sometime today, if possible.
That will be done, Chair.
Okay. Once again, thank you very much for coming forward to give evidence. If need be, we will ask you to come back, but thank you very much, and you are excused.
Chair, thank you very much. It's an
Thank
absolute
you.
pleasure. Thank you.
Thank you. Thank you.
Chair, I see that we went past the T adjournment. Could we adjourn at this time?
Yes, will the next witness be immediately available when we resume?
Yes.
Okay, all right. We'll take the tea adjournment now and resume at 22:12. We adjourn. Ms. Mlefe,
Thank you, Chair.
are you ready?
I am, Chair. The next witness that we will be calling is Ms. Sharla Chetty.
Yes.
And before we start with Ms. Chetty's evidence, Chair, there are just a few preliminary points that we wish to bring to the Chair's attention in relation to the evidence to be heard today. Ms. Chetty's evidence relates to the recommendation of the award of the network services agreement to Neotel. And there has, of course, been prior evidence given before the Chair relating to this contract, and which evidence will undoubtedly assist in truncating Ms. Chetty's evidence, as there is corroboration in this respect. However, there has not been any direct evidence from the decision maker who made the decision in respect of the recommendation of the award to Neotel. And so, Chair, that really is the pertinence of Ms. Chetty's evidence, as she will be speaking to those two main issues.
What are the two main issues she'll be
Well, the
testifying
first, Chair, will be her involvement as the decision maker in the recommendation of the award of the contract to Neotel. Secondly, she will touch briefly on the circumstances surrounding the overturning of her decision and her view on same, as those matters were covered in a document that she will be referring to.
Of course, her involvement, the first issue, we do know she was involved, isn't it? She made the decision.
Yes, Chair.
And that's the decision that was overturned by Mr. Brian Mlefe.
Certainly, Chair.
What more does she need to say about that?
Insofar as her involvement, she gives the basis upon which she reached the decision in approving the recommendation of the award of the contract, because this was one of the bases upon which Mr. Mlefe sought to overturn the award of the Neotel contract.
Well, we can look at that, and maybe she should give evidence, but one of the witnesses, I think it may have been Mr. Volmink,
Yes, Chair.
testified to whether or not Mr. Brian Mlefe was entitled to revisit that decision. And from what I heard, it appeared to me it was just a question of, seemed to be a question of law.
Well, indeed, Chair.
Whether, if the power is given to somebody who holds a certain position, and at a certain time you are not there, and somebody is acting in your position, whether you can, when you come back, you can come back after the person has exercised that power and say, no, I will reverse that or not.
Indeed, so, Chair. However, Ms. Chetty's evidence does not relate to what the Chair has referred to as possibly a point of legal argument.
Yeah.
Ms. Chetty bridges the gap that currently exists in the evidence in respect of Neotel, because there has not been given been any direct evidence from the decision maker who was involved in the approval of the award to Neotel. And so it is just that gap that Ms. Chetty's evidence would be bridging.
We did have some document that gave the reasons, didn't we? That's, obviously she can give us more meat, but am I right to say there was a document which indicated
There was certainly, Chair.
the basis of the decision? There was a memo or something.
There was a report, Chair,
Yeah,
that was prepared in respect of the different evaluation stages.
Yes.
But of course, as a decision maker, Ms. Chetty would have to apply her mind to that report. Otherwise,
Yeah.
it would be rubber stamping.
Yeah.
So it is that basis upon which she approved the recommendation of the award that we will be looking at today.
Yeah, no, that's fine. I think let her testify about the basis of her decision. But I'm not sure, other than that, whether there is really much else that she would be dealing with without repeating what other witnesses have said.
Well, certainly, Chair. The second aspect which she would have been dealing with in very minor detail would
Yeah.
be her opinion of the bases upon which Mr. Molefe sought to overturn the decision. And she does so because those were matters that were covered in the report that was presented to her by the respective evaluation teams. And she has formed the opinion that this has been covered in those reports that she considered when she made the decision to recommend the award to Neotel.
Okay, let's go and let's see.
As it pleases you, Chair.
Okay.
May I request the witness to be sworn in?
Please administer the oath of affirmation.
Thank you, sir.
Okay. Please state your full names for the record.
Sharla Chetty.
Do you have any objections to making the prescribed affirmation?
No, I don't.
Do you solemnly declare that the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "I truly affirm."
I truly affirm.
Thank you.
Thank you.
Thank you, Chair.
Yes.
Ms. Chetty, please refer to the bundle that is before you. Chair, we have marked this bundle as Exhibit BB6 rather, pardon me, Chair, and it is before you.
The liver at file containing Ms. Sharla Chetty's statement will be marked as Exhibit BB6.
Thank you, Chair.
Thank you.
Ms. Chetty, please refer to page 1 to 7 of the statement. Is that your statement to the Commission?
Yes, it is.
And on page 7 of that bundle, is that your signature appearing on that page?
Yes, it is.
The date of the 12th of April 2019, is that the date on which you signed the statement?
Yes, it is.
Are there any corrections that you wish to make on the statement?
I think it was just a spelling error on page 1, and the reference to 17.1, the tier report should have actually been the memorandum.
Okay, let's start with the first one. We are on page 1 of the bundle. Where at page 1, which paragraph?
Paragraph 2.
And what is the correction?
It's a chartered accountant. It says chartered account.
And what is the second correction that you wish to
That's on page 6. Paragraph 17.1 should be based on paragraph 11 of the memorandum that was submitted with the tier report.
Thank you. Chair, we will prepare a supplementary in this respect. Do you now confirm the correctness of your statement?
Yes, I do.
Ms. Chetty, what qualifications do you hold?
I'm a chartered accountant.
And when did you qualify as a chartered accountant?
In 2000.
What do you currently do for a living?
I'm currently employed in Transnet Port Terminals as the Chief Information Officer.
And for how long have you been the Chief Information Officer?
For 1 year and 4 months.
When did you join Transnet?
In 2003.
And what other positions have you held in Transnet?
I've held various positions, but the senior executive positions that I've held, Chief Executive of Transnet Pipelines, Chief Financial Officer of Transnet Pipelines, and Chief Financial Officer of Transnet Port Terminals.
In these various roles that you have played in Transnet, what portfolios, if any, have you managed?
I've managed the finance portfolio, I've managed the IT portfolio, and the procurement portfolio.
And what would you say your experience in relation to high-value tenders is, having been with Transnet since the year 2003, as you've stated?
So I have a substantial amount of experience with high-value tenders, and I have been directly involved in finalizing quite a few of the high-value tenders in my career at Transnet.
Yes. Now, from paragraph 5 of your statement on page 2 of the bundle, you deal with the circumstances relative to your involvement in the Neotel matter. Is that correct?
That's right.
And this was premised on your acting capacity as the group chief executive of Transnet.
That's right.
And can you take the chair through this acting appointment insofar as the delegations that you have referred to in that paragraph?
So I was acting in the period of from the 28th of October to the 1st of November 2013, and that delegation gave me full authority to act as the Group Chief Executive of Transnet.
So if I understand it correctly, and you have attached the delegation of authority as Annexure 1 to your statement, you had all the powers of authority that were vested in Mr. Brian Molefe.
That's correct.
Now, you then speak in paragraph 6 of a memorandum that you received for the approval of the procurement process, which has now become common knowledge. And in that paragraph, you speak of approval being sought from you. Can you take the chair through this aspect?
So I received documents via an email to approve the award of the tender for the network services to Neotel, and I was given the tier report together with the internal audit reports and the letters of regret and the letter of award to Neotel to sign.
Yes. Can we turn to page 11 of the bundle, please? Is that the memorandum you have referred to?
That is correct.
And do you confirm that it is directed to you as the acting group chief executive?
That is correct.
And it is dated the 30th of October 2013?
That is correct.
The memorandum also states to be from Mohammed Mohammadi, who is cited as the acting group chief financial officer, Mansika Matwane, who is cited as the chief information officer, Gary Peter, who is cited as the Group Chief Supply Chain Officer. Is that correct?
That is correct.
If you go to the last page of that memorandum, which is page 17 of the bundle, several signatories appear at the bottom of that page 17, just after the topic compiled by. Are these the persons who comprise the CFET?
These were the heads of the subject matter experts of the various departments, so they were part of the team, but not the entire team.
Yes. And these persons who are cited as signatories, can you just, for the record, state the positions that they held at that point?
So Manla Dube was the Group Strategic Sourcing, which is part of the procurement team. Fanny van der Walt was also Group Strategic Sourcing, which is part of the procurement team. And Gerrie van der Westhuizen was the Executive Manager in the Office of the CIO. Peter Volmik, Executive Manager, Governance and Compliance. Yusuf Lunat was the Executive Manager for the ICT, or the EIMS Service Delivery Function. And then Gary Pitter, the Group Chief Supply Chain Officer. Mansika Matwane, the Chief Information Officer, and then Mohammed Mohammadi, the Acting Group Chief Financial Officer.
Yes, and all these signatories, as appears on that page, recommended the recommendation made in that specific memo.
That is correct.
Now, let us please turn to page 19 of the bundle. And that is Annexure 3, which starts on the preceding page, page 18. Are you there, Ms. Chetty?
Yes, I am.
At the very bottom of page 19 appears to be an email. From whom was this email received?
The email was received from Gerrie van der Westhuizen.
And what is the content of that email about?
The email covered the tender that Mr. Pitter had called me about. He called me prior to me receiving the tender documents. The documents that were emailed to me was the covering memorandum, the tier report, the 3 internal audit reports, and the supporting documents, which was the affidavit from T-Systems to mitigate the risk, the email from National Treasury to mitigate the risk, the board resolution with the delegated authority to the GCE, to extend the current contract to Neotel, extension letters to Neotel, letter of intent to Neotel, and the 4 regret letters to the unsuccessful bidders.
Yes. From paragraph 9 of your statement on page 3 of the bundle, you then begin to set out the circumstances and the basis upon which you considered the submissions that were made to you as the acting group chief executive, pardon me. Can you please take the chair through this?
So in arriving at my decision, I had a telecon with Mr. Peter. Mr. Peter then took me through the documents that had been emailed to me. So we had gone through the tier report, which is the very important evaluation report that takes you to the various stages of the tender process and whether there was compliance or not to the processes. We then went through to the internal audit reports. I even noticed the issue around the risks that were highlighted there around the conflict of interest with T-Systems and the other company that was involved in developing the strategy for networking. Thereafter, we would have gone through the recommendation with the other relevant documents that were associated with the tier report.
Yes. Can you then turn to page 23 of the bundle? And that would be Annex 4 to your statement.
Okay.
Is that the tier report to which you refer?
Yes, that's the tender evaluation and recommendation report.
Now, in paragraph 11, and particularly 11.1 and 11.12 of your statement, you speak of this process that you engaged in considering the tier report.
Yes.
Now, in relation to the rounding of scores, as you have referred to, we have heard the evidence of Mr. Volmink in this respect, and we need not repeat that evidence, as it has been ventilated in detail. In respect of your reliance on the gateway reports, you refer to page 19 of the tier report. And this appears at paragraph 11.2 of your statement. Page 19 of the report is at our paginated bundle, page 41.
Yes, Advocate.
Can you please explain the basis of your reliance upon the gateway review report aspect that the tier report sets out?
So the gateway reports gateway review reports are very important reports that give you confidence or give you some sort of a comfort that each stage of the tender process was complied with. So the reports were green except for one aspect that addressed the rounding off issue and the conflict of interest with T-Systems. And it indicated that the risks were mitigated around those.
Yes. And who compiles the gateway review reports?
Those are compiled by the internal auditors.
Of Transnet?
Yes.
Staying on the tier...
By the way, is it in respect of this tender that there is a High Court judgment, or is that a different tender? High Court judgment relating to T-Systems.
Yeah, it is. It's a different one, Chair. It's a different
Are you
transaction,
sure?
as far as I recall. I will double check, but
Because if that is the one, really in terms of processes and all of that, hasn't that been disposed of? I think the one where there is a High Court judgment, I think it involves Neotel or is it Kijima? Was T-Systems granted a tender where Kijima was also a bidder, and subsequently Transnet brought a review application that was not opposed and the High Court judgment set aside the tender to T-Systems and awarded the tender to Gijima.
Yes, Chair, that is correct.
That is a different
It's
tender?
a separate, different matter, Chair.
Okay, all right.
Thank you.
But really, what I'm very interested in terms of this witness is why she chose the one and not the other. You know, that's what I'm very interested in.
Yes, Chair, that matter is
Why
addressed
she
in the
chose
statement.
to award the tender the way she did, and why she may think that it was wrong for Mr. Brian Molefe to change that when she has regard to his reasons.
Certainly, Chair, that is covered in the statement.
Yeah. So if there is anything that you think I'm missing, you can bring it to my attention, but for all intents and purposes, I think that's really the important part.
Certainly,
Of
Chair.
course, if she has still anything to say about the question of authority that doesn't fall within a legal issue, then she can deal with it.
Indeed so, Chair, and Ms. Chetty will be dealing with those matters. The Chair's mic is off.
Fine today because it looks like we are not, we won't have another witness, but there are times when we will be needing to go to another witness and we need to use our times fruitfully. A lot of things that really won't be disputed. It's unlike in a court of law where one might really have to deal with a lot of things because it's the court of law. But that's where my interest is as far as this witness is concerned. If you think there is something else that I'm missing, you must tell me and then we can look at it.
Certainly, Chair, and we have been mindful of that aspect.
Okay.
Ms. Chetty, can you please turn to page 28 of the bundle, still on the tier report.
Did you say 28?
28, Chair.
Okay.
Are you there?
Yes, I am.
Now, on page 28 to 30 of that bundle, of those pages in the tier report, there appears several names of persons who were involved in the different 4 stages of evaluation. Is this correct?
Yes, that's correct.
And on my count, it's a number of over 40 people who were involved in this process.
That's correct.
And this also includes the internal audit team that was involved in this process.
That's correct.
And these would be the number of persons involved in recommending the award to Neotel.
That's correct.
Now, in your next topic in your statement, you deal with the overriding of your decision by Mr. Molefe, and you touch on several issues that Mr. Molefe raised in his memorandum, which you stated to have been addressed in the reports that were provided to you. Do I have that correct?
That's correct.
In paragraph 12 of your statement on page 5, you address yourself to Mr. Molefe's memorandum.
Yes.
Can you please take the chair through that?
So, Chairperson, I was made aware of the overturning of the decision when I was presented with the evidence by the investigators. So I wasn't involved or consulted in any way by Mr. Molefe in the overturning of the decision. But I want to bring to the attention of the chairperson the fact that Mr. Molefe, when he had written the memorandum, had asked for his decision to be noted. So he did not ask for a revised recommendation or a review of what his risks were, but he basically had made a decision based on his own I think on his own opinions of what he thought the risks were at that time, and awarded it to a bidder. Even if the price was considered, that bidder would still have not been the number one bidder.
And
That is T-Systems.
Yes.
What number would they have been?
They were still being number 3 on the list.
Oh, who would have been number 2?
Dimension Data,
Yes.
yes.
And in his reasons, did he deal with why he went for number 3 and not number 2?
No, he did not. He basically, all he highlighted was all the risks around the current service provider, which was Neotel, but those risks were already well dealt with in the tier report and in the memorandum.
Yes.
And also, I just want to stipulate the concentration risk that he refers to. If you granted the award to T-Systems, which already had the IT data services contract, it would have really increased Transnet's concentration risk.
Okay.
yes, can we then turn to page 88 of the bundle, which is Mr. Molefe's memorandum to Mr. Anoj Singh, Mr. Mansika Matwani, and Mr. Gary Peter.
On what page is it?
Page 88. And that is Annexure 16.
Thank you.
Now, on page 88 of the bundle, in the purpose of submission stated by Mr. Molefe, and perhaps before we even go into the memorandum, let us go to page 94, which is the last page of that memorandum. And to place it on record that this memorandum was drafted by Mr. Brian Molefe. Do you see that?
Yes,
And it was signed by him on the 20th of November 2013.
that's correct.
Please speak into the mic, ma'am.
That's correct.
Thank you. And in his purpose of the submission, he sets out that he seeks to inform the Group Chief Financial Officer, Group Chief Information Officer, and the Group Chief Supply Chain Officer of, and I quote, my decisions to award the above-mentioned business to T-Systems South Africa in terms of your request in your memorandum dated 31 October 2013. And going further down to paragraph 2 of his memorandum, he sets out as his background, he says there, and I quote, your previous correspondence addressed to me dated 30 October 2013 with subject RFP number GSM/13/04/0722 for provision of network services, request for approval to approve the process, award contract and issue a letter of intent, inviting Neotel to further negotiations as the preferred bidder of this RFP. And he states that to be attached as Annex A, and as well as attaches the TARE report. Now, in the first opening line, Mr. Molefe is speaking of a memorandum addressed to, and I quote, me, dated October 2013. Do you have any comment to that?
Yes, I do. The memorandum was actually addressed to myself in my capacity as acting GCE at the time. It was not addressed to Mr. Brian Molefe.
Yes, and that we have seen as you have attached as Annex 2 to your bundle. Now, if we revert back to your statement at paragraph 13 on page 5 of the bundle, you speak of the memorandum reflecting a decision to award the Network Services Master service tender to T-Systems and effectively overturning your decision. And you make reference to paragraph 26 and 27 of Mr. Molefe's statement. Can you please take the chair through that? Paragraph 13 on page 5 of the bundle.
So, as I did discuss earlier, the decision that he made was on his own without consulting with any of the people part of the cross-functional evaluation team or the recommending officers. he had made the decision based on his assessment of the risk and his assessment of the pricing, which was procedurally outside the normal procurement process.
I thought your statement does say that he appears to have met with the recommending officers, but your concern was that what they had to say to him was not reduced to writing.
Yes. So there was no indication of any discussions that were held between the two parties or the various parties in order to arrive at a decision.
Yes, but to complain that what they discussed wasn't reduced to writing is one thing. To complain that he didn't consult them is another thing. He may have consulted them and had their views, but their views were not reduced to writing.
That's correct, Chairperson.
So which is which?
So it's basically he had not reduced his discussions with them to writing.
So is your position therefore that he may have consulted, but he didn't comply with whatever procedure, because the procedure requires that their views that they expressed to him when he consulted them be reduced to writing?
Yes, Chairperson, that view is based on the fact that per the PPM, if there is a decision to overturn or overrule a decision made by the recommending officers, that the reasons for that, it's like a dispute being lodged, has to be referred back to the cross-functioning sourcing team or the evaluation team to review those reasons and then come back with a recommendation. It's not common practice that one would overturn a decision, not have the recommendations in front of your remotivation as to why that decision was actually, whether you'd really consulted with all the recommending officers in making that decision.
Well, you need to make a distinction, and I say that so that you can clarify the position to me, maybe much more than you may have tried to do. There is a difference between somebody who must make a decision being given recommendations by another body or another person and making his or her decision after having regard to the recommendation, and that person may make his or her decision in accordance with the recommendation or against the recommendation. That's one scenario. The scenario that we are dealing with is a situation where you had made the decision. Okay? Is that right? You had made the decision. When you made the decision, there was a recommendation, or there were recommendations in front of you. Is that right?
That is correct, Chairperson.
So, what you are talking about, does it apply to the situation we are dealing with, the provision that you say says the person must go back to the recommending officials? Does it apply when a decision has already been taken by the person who holds the power to make the decision? What's your understanding of what the procedures are at Transnet?
So my understanding of the proceedings, Chairperson, is that once a decision has been made, generally that decision is not overturned unless there's something materially that you really have not considered. And that obviously will have to go back to the recommending officers that made that decision. But in this particular case, the decision had been made by myself, and about 20 days later, that decision being overturned, but overturned without any resubmission to that office. So if there's something material that happened in that 20-day period that you could say was never something that was even considered during the bidding process, that is a new material risk that has arisen, you are allowed to look at whether that award would continue or not.
So your evidence is that there was nothing wrong with Mr. Brown-Molefe overturning your decision as long as he followed the procedure that you understand to be applicable. You say he was allowed in certain circumstances to overturn, he would have been allowed in certain circumstances to overturn your decision. Is that what you're saying?
So Chairperson, what I'm saying is that if there's a material risk in any award that we do currently, if there's a material risk that has arisen after the award has been made that could jeopardize the organization, that award has to be re-looked at so that you can mitigate, see whether that risk can be mitigated or not. If it can't be mitigated, then obviously you'll have to go back to that evaluation team and look at maybe the other bidders.
Yes, no, but let's not talk in general. I'm talking about Mr. Brian Mlefe, and I'm talking about the tender that came before you and you made a decision.
So Chairperson, in this particular case, Mr. Mlefe, the risk
Did he have the power to change your decision? Whether or not he was justified in changing, that was a different question. Did he have the power, generally speaking, to change the decision if a certain situation existed?
I believe he would have the power.
He would have the power. That's your understanding.
Yes.
But do you know under what circumstances he could exercise that power?
Chairperson, generally that will only be done in cases where there's a material risk to the organization that has not been evaluated or even considered, that arose, a brand new risk that arose directly after we made the award. And if you look at Mr. Malefe's memorandum, all the risks that he highlighted have already been covered and mitigated substantially in the tier report. So the risks that he had and the reasons he had given for overturning were not justified, in my opinion, Chairperson.
Do you know whether in a situation where somebody has the power to make a decision on a tender and has made the decision, whether the same person whether the power to change that decision resides with the same person or with the person occupying the same position, or whether it can only be changed by a higher authority within the organization. So if, in other words, the procedure that you have told me about, if, let us say it was Mr. Brian Mlefe who had made the original decision, in this case not you, would he have been entitled to say, no, I want it back, I want to change my decision under certain circumstances, or would he have needed to report to somebody higher like the board or a certain committee of the board and say, I made this decision on such and such a day in regard to this tender. It has since been brought to my attention that the following has happened, or is the position something maybe I didn't know at the time. Could you please change it, that is named the board, somebody higher, or would he be free to change it himself?
So Chairperson, because the authority was delegated to him by the board, and he wants to change a decision that he made based on the authority granted to him by the board, ideally he'll have to go back to the board if he wanted to revert that decision. Because that delegation of power was granted to him by the board and was concurred by the Board Acquisition and Disposal Council.
Well, I understand your answer, but the reason you give, I'm not sure that it supports it, because if the board has delegated the power to him, it may have been intended that he should exercise the power.
Yeah, we've had Chairperson, because this is an unusual circumstance where you're actually overturning a decision that you've made based on the power that you were delegated. I would think that because it's such a high value tender, you may have to go back to the board, maybe from a reporting perspective, to say, I need to retract the decision, and these are the material risks why I need to retract that decision. But it's not governed in any document or in our PPM, our Procurement Procedure Manual, any of the documents that I'm aware of that one has to, but I think one has to apply their mind from a sound governance perspective.
But your evidence is that in terms of Transnet procedures and the rules and so on, he was entitled to change the decision in certain circumstances, and you
Yes.
say if something arose after the decision had been made,
That's correct, Chairperson.
that put the organization at risk and so on.
That's correct,
Okay.
Chairperson.
Thank you, Chair. Ms. Chetty, can I please refer you to page 12 of your bundle? And that is the memorandum that was submitted to you for the approval of the recommendation to appoint Neotel. At paragraph 6 of that memorandum, that is the delegation that you've just spoken of, in terms of which power, or rather, subject to the approval of BADC, the authority to approve the sourcing strategy, RFP, advert, and award was delegated to the Group Chief Executive Officer. Is that correct?
That is correct.
And at the last line on that paragraph, the BADC resolution had delegated this authority to the Group Chief Executive. Is that correct?
That's correct.
Can we then turn to page 262 of the bundle? And that would be the Procurement Procedures Manual. We'll just be referring briefly to one aspect in that manual. Are you there?
Yes, I am.
At paragraph 20.5, the heading there is disagreement regarding award of business. Is that correct?
That's correct.
Now, at 20.5.1, it states there that should a dispute arise between the recommending officers and the AC, being the Acquisition Council, regarding a submission after the AC has referred the matter back to the recommending officer for remotivation, the matter must be escalated to the entity's CEO for a final decision. Is that correct?
That is correct.
And it also it goes further to talk about the recommendation of the evaluation team. If that is in conflict with the opinion of the end user, the matter must be referred back to the AC for a ruling. Is that correct?
That is correct.
Now, if we refer to Mr. Molefe's memorandum, can we please go to page 92, at paragraph 7, rather, of his, so that would be Annex 16 in the bundle. And we will be referring to page 92 at paragraph 7. Are you there?
Yes, I am.
Mr. Molefe states there that I have the following specific concerns with your
I'm
recommendation.
sorry, did you say we must go to page 16 of the bundle?
No, Chair, Annex 16,
Annex 15,
16, 16,
16.
and we are at page 92, Chair.
Okay.
We will start with paragraph 6 of Mr. Molefe's memorandum, where he states there, I have given consideration to your recommendation as per your previous correspondence mentioned earlier. Now, if we were to turn back to the first page of that memorandum, at paragraph 2, and we've already covered this issue, Mr. Molefe refers to the memorandum as having been addressed to him. Is that correct?
That is correct.
And if we were to refer to your Annex 2, it is clear that the memorandum is directed to you as the acting Group Chief Executive. Is that correct?
That is correct.
Now, when we consider the Procurement Procedure Manual, together with the delegation to the Group Chief Executive, the result would be that in the result of a dispute, the matter would be referred by Mr. Molefe back to himself. Is that not the case?
Yes, it is. That is the case because powers have been delegated to him by the AC. And he's also the CE, so matters are being referred back to him.
Yes. And that would be logical insofar as good governance is concerned.
I would say that's illogical in terms of governance.
Now, going back to paragraph 6 of Mr. Molefe's memorandum.
I'm sorry, what's illogical? Let me understand
so, Chairperson, this particular paragraph in terms of section 25 of the Procurement Procedure Manual, it says that if you have a dispute between the recommending officer and the AC, that matter must be referred back by the AC, and then the final decision gets made by the CE. Now, in this case, all powers from the AC have been delegated to Mr. Molefe or the GCE. So he basically will be the final decision maker, because it's illogical that there's no AC involved here now anymore, because the powers have been delegated to Mr. Molefe. So if he's disputing it, he refers it back to the recommending officers, and then he still makes a final decision. There's no intermediate party like the AC involved here, which for a high-value tender is kind of illogical.
But assuming that he had power to deal with it, if he did it differently, would he not be acting outside of the procedures? Was there any other way prescribed in which he could deal with it, other than dealing with it in that way, if he was to comply with the procedures?
So,
in other words, was it his mistake, or was it the mistake of the procedures? Because if that's what the procedure required, then it's not his mistake, it's the mistake of those who drafted the manual.
Chair, I would say it's a mistake of, maybe, in my opinion, the AC of granting him full authority.
Sorry?
Chair, I would say it's, in my opinion, maybe a mistake of the AC for granting him full delegation, where there is no intermediate party involved when there are disputes, because he's a sole decision maker in this aspect. Basically, there's no intermediate body that can evaluate whether the recommendation from the recommending officers should be disputed or not disputed.
So as far as you know, on the procedures that were applicable, once the delegation was given to him, it had to be dealt with in that way.
Yes, he complied based on what was delegated to him, Chairperson.
But that procedure, is it applicable before the authority that has power to make the decision has made the decision, before he or she makes the decision, or does it apply after the authority or person that has the authority has decided? I have a sense that what may be contemplated, but I haven't checked, what may be contemplated is that if the power to decide on a tender vests in you, and you have got recommendations from other people who are making a recommendation that you should award the tender to A, and you take a different view, you think the award should be the tender should be awarded to B, you should go back to them before you make the decision, so that you ask them, what about this, what about that? You tell them your concerns, and you hear what they have to say. Maybe they will say, oh, we overlooked that, you are right. Or they'll say, we actually did consider that, but that notwithstanding, we came to this conclusion because of A, B, C, D. But then you must still make up your decision whether, having interacted with them like that, you stick to your view that the tender should be awarded to B, or you agree with them that it should be awarded to A. I have a sense or suspicion that maybe that's what it's talking about, but I haven't checked. Do you know whether it applies to that situation, or it applies to the situation where a decision has been taken?
So this is before a decision has been taken. So this particular paragraph of the Procurement Procedure Manual refers to before you make your decision.
Yes.
And you've still got a recommendation at hand.
Yes.
That if you're not happy with the recommendation, you don't believe it's covered all the points, you can send it back to recommending officers for them to come and remotivate based on new things that you've highlighted to them. In this case, there is no resubmission or anything, but the award was already made on the 31st of October by myself, Chairperson. So it is after the fact. And he doesn't indicate any new material risks that could have resulted in the overturning of the decision. So he supplied the paragraph 20.5, but why I said it was illogical goes to the fact that, he made that decision on his own, but it was also after the award was made. So it's not exactly what the paragraph was aimed to do. It was aimed to finalize your decision before, arriving at, you arrive at a decision.
if you are correct in that, then I would understand that. I would understand that. But I wouldn't see it as illogical, because all it would mean is that it recognizes that there are people who have dealt with the matter before it comes before you. They've considered it, they've made recommendations, and I assume they would give reasons for their motivation. It simply says, if you are not persuaded to accept their recommendation, just go back to them, put your concerns to them, hear what they have to say, then make a decision.
That's right.
And when you make the decision, you can go with their recommendation or go against it. But you have had you have followed a process where you give them a chance to address your concerns. You have heard what they have to say, and you make a decision on an informed basis. So that wouldn't be illogical to me.
Yeah, Chairperson, the part of the illogical was the AC granting full delegation and not having any element per the PPM where you could resort to, where a body can review and check that, the recommendation from the officers, you've taken into account all the motivations, all the reasons. So I think that's the part where I refer to as being illogical, in my opinion, Chairperson.
Okay, all right, thank you. Ms. Molefe?
Thank you, Chair. Can we go back to page 92 if you had moved from there? 92 of the bundle. Are you there?
Yes.
At paragraph 7 of that memorandum, Mr. Molefe lists the several concerns that he had with the recommendation that you had approved. Well, in his paragraph 7, he states there, I have the following specific concerns with your recommendation and responses to me, including the responses to me in the various meetings held with the recommending officers for remotivation, which is discussed further in this document. And those 5 issues are the issues which you address as having been addressed in the respective evaluation reports, and as well as by the internal audit component of Transnet. Is that correct?
That is correct.
Can you please take the Chair through those 5 grounds and your reasons for stating that they were not valid reasons provided by Mr. Molefe?
So, Chairperson, the counterparty risk and alienation of state assets, that risk was covered quite substantially in the memorandum and in the tier report, where it spoke of if the Competition Commission approved the sale to Vodacom, that Neotel will still continue with their services. So that could have been dealt with contractually between Vodacom and Transnet should that risk have materialized. The concentration risk, as Transnet is Neotel's largest client, I think, Chairperson, I did state earlier that T-Systems also is an IT data services provider to Transnet at the time. And by awarding the contract to them, you also would have increased your concentration risk. The triple BE partners, Chairperson, as part of your evaluation criteria, your BE accreditation is taken into consideration in your evaluation points. So that was already considered. The information security incident that resulted, Chairperson, those risks were covered in detail in the tier report and in the memorandum, where it was indicated how those risks were being mitigated both by T-Systems and by Neotel, and how they've increased the security for Transnet, again, which could have been dealt with contractually. The CCTV network issues, Chairperson, those are isolated incidences that were brought up that could have been dealt with as part of contract management with Neotel at that time. So they were not new risks that Mr. Molefe had addressed, but basically highlighted risks that had already been covered for and being mitigated in both the tier report and in the memorandum.
Can we then turn to page 93 of that same memorandum? Are you there?
Yes.
At paragraph 21, Mr. Molefe makes reference to strict timelines having been set by Transnet. He says there, post the close of the final offers being submitted, T-Systems indicated that they unfortunately, due to the strict timelines set by Transnet, only managed to get confirmation from their shareholder on certain pricing elements, and that they would be in a position to reduce the price submitted the week before by a further 248 million. As we have heard, and as is now common knowledge, T-Systems' bid was unsuccessful due to pricing, amongst many of the other matters that you have spoken to.
Yes.
Can I then refer you to page 36 of the tier report? Paginated page 36, rather.
I'm there.
In paragraph 18 of your statement, you deal with this pricing element relative to the tier report,
Yes, that's correct.
as well as the possible price reductions that are spoken of by Mr. Molefe in his memorandum.
That's correct.
Can you please take the chair through your opinion in that respect?
Before she does that, are you able to say anything about Mr. Brian Molefe's decision to overturn your decision, other than that he took a different view on certain matters to the view that you took? Is there anything more you can say about this other than I took this view, he took that view? I disagree with him.
So, Chairperson, if I look at how he took his view, I would say that it's not in compliance with governance, because he evaluated his risks, his pricing that he considered, Chairperson. You can't consider pricing, a revised pricing, after your best and final offers have been submitted. So he made decisions. He
I'm
didn't
sorry,
only
just go
value-
back a bit. Just start again. I think I missed something. Just start again your answer.
So Chairperson, the manner in which he overturned the decision, I would say was procedurally not correct. By that I mean is that he had said he had consulted with various people, and these were the risks that he had highlighted, but those risks were already mitigated. Then he further goes on to state that the price of T-Systems need to be reconsidered, and the best and final offer would be taking into account the 248 million that he refers to. Chairperson, those are considered as not being fair and transparent in a bidding process, because you can't consider pricing once a bid has been, your best and final offer has been submitted. You can't say, I need to entertain the pricing of one bidder and not give the opportunity to the other bidders to review their pricing as well. So all of those things make the decision that he's made to overturn procedurally unfair and not transparent.
Talk to me about the not transparent part. Why are you saying they were not transparent?
So Chairperson, T-Systems, when they were asked to submit their best and final offer, they did submit their best and final offer, and when they were asked to confirm that offer, when they went to all the bidders and asked to confirm, T-Systems said, yes, that is my offer, but we've been in discussions with our partner, and they are considering giving a further discounted price of 248 million. Now, that could not be considered because your best and final offer was already in, like all other bidders that were given the time period to submit that offer. And even considering that offer, they still they came out still lower than Neotel in the pricing. So if you look at all your evaluation criteria, which you consider is your commercial and your technical, Neotel still made it in terms of being the preferred bidder.
Well, I may have had evidence about something that was brought in about after the best and final offer. Ms. Molefe, I continue to be concerned about the significance of this witness evidence.
Thank you, Chair. We are nearing the conclusion.
So I continue to be concerned. You know what my concerns are. Maybe you can deal with her, lead her evidence in a way that tries and removes my concerns.
Thank you, Chair. We will be dealing with the last matter in Ms. Chetty's evidence, and that's in relation to the pricing.
Yes, okay. You must tell me if I am missing something. Feel free to say if you think I am missing something.
Thank you, Chair.
Okay, all right.
Ms. Chetty, can we go to page 94 of the bundle?
What page?
94.
Okay, 94.
Yes.
Okay.
And that is Annexure 16. Are you there?
Yes, ma'am.
At paragraph 22 of his memorandum, Mr. Molefe states, and this is evidence that has been given, but it becomes material insofar as your analysis on the pricing aspect. He says there, I approve that the 248 million be taken into consideration as part of T-Systems' best and final offer, as the commitment was made in writing to Transnet, and shortly after the best and final offers have closed. And I don't believe that any other bidders were prejudiced by this. Do you have any comment on this paragraph?
Yes, Advocate Molefe. The best and final offer has already closed, and he said it was still acceptable to accept an offer thereafter because he believed it didn't prejudice any of the other bidders. But he didn't give any of the other bidders a chance then because it's a revised offer that he's being considered. Ideally, you would give all the other bidders a chance then to revise their offers as well, or give them opportunities to resubmit their best and final offers.
Yes. And at paragraph 23 of that memo, Mr. Molefe further goes on to say, I further do not believe it is necessary to request another best and final offer from any of the vendors, as all three preferred bidders were given the opportunity to confirm if the prices submitted are accurate and if they are omitting anything, and if they have omitted anything, rather. And you have just given evidence that, in your view, as the other bidders would not have been given another opportunity as T-Systems, as would have been afforded to T-Systems, that this would be unfair.
That's correct, Advocate Molefe, because the other T-Systems was afforded a bit more time than the other bidders, so they could have raised an objection to say that they could have done a better offer had they been given more time.
Yes, and at paragraph 24 and leading to 25, it says there, as per the tier report, should this 248 million be taken into account and business not be awarded to Neotel due to the risks stated above, T-Systems would be the preferred bidder. What is your comment to that?
He is, Advocate Molefe, he is correct in that T-Systems does come out to be bidder number 2 if the 248 million is considered. And if Transnet decides that those risks are new risks and they're material risks, then the award to T-Systems, he would be then correct as bidder number 1.
Yes, and if this 248 million is not taken into account?
T-Systems wouldn't be bidder number 1. If you exclude Neotel, it would be Dimension Data.
Second to Neotel.
Yes.
And at paragraph 25, he states there that management must ensure that more favorable prices are agreed with T-Systems to at least be at a similar level to the prices submitted by Neotel as part of the post-tender negotiations. What is your comment to that?
So, Chairperson, you're allowed to negotiate to market-related prices. So there's nothing wrong with negotiating to market-related prices, provided that Neotel was excluded on a proper basis.
Yes, and insofar as this pricing element, the tier report sets that out in the paginated bundle, page 36.
Is that 36?
36, Chair.
36, okay.
And through to page 37.
Okay.
And the evaluation of the prices was divided into 4 different categories. The first one appears on page 36. Do you have it there?
Yes, I do.
And the first price evaluation for network services, RFP, would be the consideration of pre-due diligence. Is that correct?
That's correct.
Can you please take the chair through the evaluation outcome?
So Chairperson, if you look at the evaluation outcome, before the due diligence was done, bidder number 3 actually scored higher than bidder number 1 and bidder number 5. So
And-
bidder number 3 was with dimension data at that time, but it was not considered a like-for-like comparison.
And why was that the case?
With pricing, you've got to reach a common basis and make sure that everybody is using a common basis on the templates for pricing. So they had to go back to the teams and then ask them to reprice on a common basis.
And insofar as the second aspect of the price evaluation that appears on paginated page 37, can you take the chair through this second stage, which is entitled the Post Due Diligence?
So the post due diligence revealed that bidder number 1, which is Neotel, scored the highest points, and T-Systems came out to be the second ranked in terms of pricing. Thereafter, after the normalization exercise was done, it revealed that T-Systems came out as the third preferred, and Neotel still the first preferred bidder from a pricing and normalization perspective.
Yes, and the post-normalization would be the third category of the pricing evaluation.
That's correct.
And what was the outcome in that respect?
Where Neotel was a number 1 bidder and T-Systems ended up being the third preferred bidder.
And who was the second preferred bidder?
It was Dimension Data.
And lastly, in respect of the fourth price evaluation aspect that was considered, can you please take the chair through that?
So that was basically just an evaluation done to say if the 248 was considered, where would T-Systems fall? And they basically came out to be the second right tenderer. But it clearly says there that the price reduction could not be taken into account since the final pricing had already been submitted.
Yes, and that appears immediately above the heading, the fourth price evaluation.
That's
The
correct.
yes, that being the last sentence of that entire paragraph.
That's correct.
Is there any other matter you wish to bring to the chair's attention in respect of the pricing?
No, there isn't, Chairperson.
Is there any other matter you wish to bring to the chair's attention insofar as the consideration of Neotel against T-Systems?
No, Chairperson.
Chair, unless there are any other further questions, I have no further questions for Ms. Chetty.
Thank you, Ms. Mlefe. Thank you, Ms. Chetty, for having come forward to give evidence. You are excused.
Thank you.
Thank you.
Thank you, Chair. Mr. Mokoena will address you.
Mr. Chair, that concludes the business of the day, and we'll resume on Monday with Mr. Van der Westhuizen as the next witness.
How long is it likely to be? Will it take more than
It's
a
1 day.
It's 1 day.
Yes.
Should we start early or should we not? We'll finish within 1 day.
We'll finish within
so
1
we
day.
can start at 10.
At 10 o'clock, Chair.
Oh, okay.
Definitely, yes.
Then we'll start at 10. We will adjourn for the day, and on Monday we will start at 10 o'clock. We adjourn.